I'm your host this evening, Taylor Hudak. All right, well, first of all, I want to thank all of you for joining me here today. I'm really looking forward to our discussion. But before we do open it up to the panel for some questions and just general talk about what happened in court today and about this case generally, I would like to now hand it over to Craig Murray to just briefly break down the main points of what happened in court today.
Today we saw the defence present their arguments as to why they should be allowed to appeal, and they covered the major things at issue in this case. Previously at the High Court, we've only been looking at the arguments about Julian's health and the conditions in American jails. Whereas today we actually got into the substance of the case. We got into issues of free speech. We got into discussion of the major crimes of the United States armed forces and the fact that WikiLeaks exposed major criminal activity by the state. That was stated in terms. It's rather lovely to hear that in court. You don't expect to hear that said in such an official session. And we got into the questions of whether or not Julian can expect a fair trial at all in the United States, and also the whole question of freedom of speech, the right to know of the public of things done in the names by government, and even questions of whether or not he might potentially face a death penalty, or whether the United States government may, having got into the United States, add new charges or develop the accusations against him. So it really was a very full and interesting day. And I would say as a scene setter that this is the first day in many, many days of hearings on the Assange case at different levels. This was the first day I have ever come out of a court feeling that the court behaved in a reasonably fair manner, that they were not hostile or aggressive, but that questions the judges asked were reasonable, framed reasonably, and that there was no sign of aggressive intent towards the defence. So today felt like you were actually in a courtroom, and at no stage in the Assange process has that really felt like that before.
Yes, that's a very interesting point. I know I came out of the courtroom today when the court hearing had concluded, and I felt that the defense made a very strong case. I agree with you as well that it was quite extraordinary to be able to hear the significance and the impact that WikiLeaks publications had in foreign courtrooms as well. So that was very important that was addressed. I see some of you over here nodding, you, Emmy, in particular. What is your response to some of the points raised here?
Well, it's very interesting. I was outside the court throughout the day, wasn't able to go inside, so it's very interesting. I wanted to ask, did the US government have a say today at court at all?
No, they didn't.
It was completely on
completely defence. The US government will present its case tomorrow.
Yeah, well, it is promising, but of course, throughout the court hearings, we've had this adversarial relationship between how the courts handled both journalists, members of the public, and of course the defence team. We've had that continuously. So it's hopeful to hear that they behaved in a half-decent way. Of course, we've read in publications, especially Declassified UK, that both judges are very deeply entrenched within the British establishment, and one makes one very doubtful of the outcome. But it is an opportunity for the defence team to put across all the important points, and extremely important for the historic record, which will revisit this case, being a very historic case, that as much as information is put out in the public record, and especially in the court records. And so I'm glad to hear that it was allowed to be so. So thank you for being there and letting us know.
Yes, this I think was the first time that the defense was able to address their points on appeal before a court, especially the points in which the judge, the magistrate judge, ruled in favor of the prosecution in that initial ruling. Chris, you were present in the courtroom. Any general thoughts or impressions today?
Yes, I would caution against being too sanguine about the attitude of the judges, although of course Craig is right. I covered the trial of Chelsea Manning, and the judge was not only respectful, but I would even at certain points describe as motherly, and then knifed Chelsea in the back. So the demeanor is interesting, but it may not be significant. I think we do have to remember that in the afternoon they kept hammering the defense about the failure to adequately redact and put people's lives in danger. This is the canard that the U.S. uses as a big bludgeon to go after Julian, although, of course, even they have had to admit that they have no evidence that anybody was actually harmed. But they asked that question several times. I think the most interesting aspect for me, again, occurred in the afternoon, and that, I think, was the correct focus by the defense on Vault 7, because he's not charged. Vault 7 was the leaking, what was it, 2017, Craig?
Yes.
Yeah.
Yes.
To the leaking of the CIA hacking tools, their ability to use our smartphones, even our cars, internet, TV, anything, even when they're off, to monitor us. And that really triggered the fiercest animus against Julian. That's when Mike Pompeo, shortly after that, he was then the head of the CIA under the Trump administration, attacked WikiLeaks and Julian as what hostile, non-state intelligence agencies. I may have that slightly garbled. And then you really saw an acceleration towards the extradition, which the Obama administration had not pushed for, what they call the New York Times problem, because of course what Julian and WikiLeaks did was no different from what the Guardian, El País, Le Monde, Der Spiegel all did in terms of publishing. They published this in a kind of joint project. And I think that was an important point, because although he's not charged for the release of the publication of the information in Vault 7, it's very clear that the engine of the extradition, the forces that are pushing for his extradition, come out of the CIA, and that if he is extradited and ends up in the Eastern District Court of Virginia, which is a kind of bastion of CIA, it's very close to the CIA, and the jury pool is all pulled from people who have relatives, friends, connections to the CIA and other national security agencies that are all headquartered in that area. And that's why the government wants it there, because they win those cases. I don't see, and see what Joe and others think, Craig, I don't see how they're not going to hit him with these charges. And potentially, at that point, and I think that the defense was correct in raising, not only would these charges exacerbate, though he's facing 175 years already, but then it really becomes, the potential of even the death penalty becomes possible. So that was, I thought, the most interesting aspect that I saw this afternoon. Yeah.
And of course, they gave the alleged whistleblower
40
years.
Yeah, 40 years. Yeah.
Well, that's right, and also one of the expert witnesses, Maureen Baird, she did point out after a question on re-examination by Mark Summers in the extradition hearing, that it is the CIA that if the charges are not aggregated to death penalty, they can make it as actually worse than death by imposing SAMs anytime they like. And I think Mark Summers really pointed that out today.
And we should explain what SAMs are. So
Special administrative measures.
And I've watched them at work,
Yes.
because they were used after 9/11, when the American government, at the behest of the Israelis, shut down all of the Palestinian activists and all of the major Palestinian organizations like the Holy Land Foundation. These people are still sitting in jail. So I covered the case of Fahed Hashmi, and he was put in isolation in the MCU in New York for 23 months. And now Fahed his crime was that he was smart and articulate, and had been a leader of the Palestinian movement. At his trial, they actually played surreptitious tapes or recordings that they had of him speaking about Palestine at the university to convict him. He was doing a graduate degree, I think, at the University of London, London School of Economics, and his roommate had sent waterproof socks, I didn't even know such things existed, to the Taliban or Al-Qaeda or something, and had borrowed his cell phone. I mean, it was just really flimsy. But the point is, when they brought him into court, he was a zombie. He didn't know where he was. They had broken him, and they know how to break you scientifically. And of course, they're applying these psychological measure, torture, to Julian. And so these SAMs are very pernicious. They isolate you. They restrict your ability to see the quote-unquote evidence used against you. Even your lawyers can't see it. It's extremely difficult for you even to have contact with family members. It's complete social isolation. But just to throw that out, that in the diplomatic note, which has no legal validity really, they said they won't impose SAMs on Julian. This is part of the assurances. They won't impose SAMs on Julian unless, of course, he warrants them. So they can. But it's important that we have other SAM-like measures, MCUs, management control units, that really replicate. I mean, one of the things they said in the diplomatic note is he won't go to Florence, Colorado, this high-tech supermax prison pre-trial, without saying that nobody goes to Florence pre-trial.
Right.
So it's really cynical. But they have lots of ways to break you. I also teach in the prison system and have for 14 years through Rutgers University and the college degrees. So I kind of see it up close. And even there, on a smaller scale, they'll pull my students for minor, like having a cell phone, which was sold to them by the guard, of course, and throwing them in for a year, and they come out. They say after 6 days they start to lose it, but having taught students that come out even after a year in isolation, they don't ever fully recover. So it's important to know that they have all sorts of mechanisms within the bureaus of prison that are designed to destroy you. It's routine within the American prison system, and what they do is they break you and then they drug you. So what they want to do is break you in isolation and then give you psychotropic drugs where you're basically a zombie and you go down the hall to the mess hall shaking. This is routine within the American prison system, but it's especially used for high-profile cases, as it was for these Palestinians, as it was for Fahd Hashmi, and as it will be for Julian if he is extradited.
Well, it was very interesting that the judges who didn't seem to know all that much about what had happened in the past were asking questions about the assurances. And do we have these assurances here? They wanted to read them. But one question they asked is if there was an assurance that would assure against Julian's charges being aggregated to a capital offence in the United States. And of course there aren't.
Yeah.
So for everybody listening right now, I just want to give some additional background information. Initially, it was stated that Mr. Assange would be subjected to SAMs, or special administrative measures. Chris outlined what that is very clearly. This is beyond solitary confinement. Now, of course, later on during the extradition proceedings, the United States then came forward and provided a so-called assurance that he would not be subjected to SAMs, or special administrative measures, but we do know, of course, there's a loophole with this particular assurance, and all of them, in fact, which allows for them to be overturned basically at any moment. And another point, just to make clear for the listeners again, that once Julian Assange is on U.S. soil, if he is extradited, again, still unclear at this point, and we would all hope for that certainly not to be the case, and those who do in fact care about press freedom, if extradited, additional charges could be brought forth which would make him eligible for the death penalty. And that was also another point that was addressed in court today by the defense. Before I hand it over to Joe, because I would like you to weigh in as well on this point if you would like, I do want to welcome our another guest joining us, Fidel Narvaez, former employee of the Ecuadorian Embassy. It's great to have you with us. I'll get to you in 1 second. First, I'll hand it over to Joe for a few comments.
Yeah, I'd like to set the scene. This court tried to limit the amount of coverage.
Yeah.
That is
They-
true.
In previous cases, in the extradition hearing in 2020 and in the High Court hearing in 2021, October, you could be anywhere in the world. If you were a legitimate journalist, you can get a link to watch it. This, for some reason, they have limited it to people that you had to be on English or Welsh territory. No explanation for this, why this is different now than before. And then we went into the courtroom. It's quite a beautiful courtroom. Very small, however. I counted 7 rows of about 15 people across. And against this, I think, walnut wooden paneled walls and bookshelves with law books is an iron cage on the top left that was empty because Julian decided, what we learned from the court, confirmed by his lawyers, that he decided not to come today. He could have come. He also didn't want to watch it on video link. The story was that he was ill. So you can imagine what he's going through, and he wouldn't want to necessarily watch this travesty anymore. However, he may have been encouraged, and not overly, as Chris is pointing out, by this incredibly strong presentation by his lawyers that left me feeling, and I tried to resist this feeling of some high expectation. How could they lose this case when you hear this argument? There's just no way if there's going to be any kind of semblance of justice here. And what I particularly liked was the simple way they laid out a timeline to show what the U.S. motives were here. And that there's no difference between any authoritarian state crushing a journalist who is reporting and revealing their crimes that the United States do. And I think this is a hurdle for Western leaders, for the public, because we're continuously thinking that only other countries have this type of behavior by their leaders. We're not capable of that. We're the good guys. It's all the others that do that. And I think that's a huge hurdle to overcome. But today we heard the U.S. and their war crimes, Julian exposing that is why they clearly went after him. And we saw that Vault 7, yes, was an important milestone in this because that got Pompeo after him. And he is the driving force behind this prosecution. And it's horrible, horrible what we saw. We also saw a lot of good arguments about the difference between the Extradition Act and the Extradition Treaty. Because the Extradition Treaty between the U.S. and UK says there cannot be an extradition for political offenses. That was left out of the act, the implementing act in Parliament. But as his lawyer's argument, that didn't mean that they didn't in some way refer to it. And in fact, there is a referral, correct me if I'm wrong, but correct that, you cannot extradite someone if you violate their on ethnic or religious or political opinions. Is another reason you cannot extradite someone. So even the act does prevent a political opinion. And they went to great lengths to show that he had a political opinion, and espionage being a supremely political crime, and that there are studies and many authorities say this, it's not just colloquially thought of. So all in all, it was an encouraging day, but again, I don't think one should be carried away with this because we're not dealing with a necessarily level playing field here.
May I say, back to the diplomatic assurances of it, I thought it was remarkable that in a court of law, a political instrument like diplomatic assurances is given deference. Because we had the Home Office minister referring to the court's opinion, and then we had the whole court referring to and accepting diplomatic assurances, which is a political instrument. This is just highlights to me that it is very much a political case, which they're trying to make an appearance of legality or legal process or court process. But they adhere and remain faithful to the political objectives that this particular prosecution is trying to achieve, which is of course limiting free speech, diminishing the First Amendment, and putting the fear of God in every truth-telling journalist and publisher around the world.
I just want to add that the judges are senior judges. As we were discussing on the way over here, there's really no promotions they can get, which is a good thing. So it'd be hard to pressure them as they did with the magistrate in this case, who was a young judge and got a promotion after that case was over. So I think they showed that they were intrigued by this case. They clearly had a lot of knowledge. You could tell by the way they were reacting. They didn't really know this case at all. So I think that's something encouraging. That they were intrigued by this, and particularly when there was a discussion about the fact that he would not have First Amendment rights, not being abroad, but when he's on U.S. soil. I think they seemed to be taken aback by that. I thought, well, they found that to be something that they should find out more about. You know, I think they were a little troubled, maybe. Maybe I'm reading too much into it. But
Let me just ask, and I may be wrong, you can correct me, but it's my understanding that we don't know that they have talked, was it Pompeo, I think, who said that he would not have First Amendment rights.
And Kronberg.
Absolutely.
Kronberg, it was Kronberg, the Judge Kronberg, but it's not, we don't know for sure, do we? That
Kronberg
if-
said he could raise that argument.
He could.
And
And Pompeo said
and
it more
Pompeo.
directly. He will not have.
Right, the Pompeo did.
But there's actually no legislation that says that he should have First Amendment
Right,
rights.
so the
So there's an absence there. There's
right,
a void.
but I'd always interpreted that as still open or not. Do you think that it's a fait accompli that if he is extradited, he will not be granted First Amendment rights?
I think when if it comes to the Espionage Act, if that's challenged, that this is a conflict with the First Amendment, since he's acting as a journalist here, I think that might be when they decide. Kronberg may say, I think I'll argue that he doesn't have First Amendment rights. So it becomes a critical issue in the case.
Just to provide some background here, we heard a little bit in court today about this particular issue where Mr. Assange may not be afforded First Amendment rights to free speech and that of the free press, even if on U.S. soil. The reasoning behind that potentially is because he is an Australian citizen, not a U.S. citizen, so he would not be granted these rights. However, he is subjected to the U.S. Espionage Act. So just some background information there. Any other
Well,
thoughts on-
I'd
go
just
ahead.
like to say that Mark Sumner's point was that there's nothing really written in stone about what happens to foreign
Right.
nationals, right? So, in fact, Pompeo and Assistant Attorney General Gordon Kronberg both have threatened to say that he doesn't have any rights. And so Sumner's point was that the UK cannot expose somebody to the risk that they will not be protected under the First Amendment.
Well, and we should be clear that all of the detainees in Guantanamo did not have First Amendment
I
rights.
thought of
Yes.
Guantanamo when
But this is Europe. I mean, under the European Convention of Human Rights, I mean, there has to be an equivalence with Article 10, right?
They weren't on U.S. soil though, in
Well,
Guantanamo.
Technically, I mean, yeah, that's why they
One
put
reason
them
they're there, exactly.
right, and
Exactly.
they actually legally classified it as, I forget the term. It was kind of Orwellian, no place or something like that. That it didn't have nobody had any jurisdiction because it was outside of all legal
But
jurisdiction.
that might tell you that they're afraid that if they bring him inside the U.S., that he could successfully argue that he had this right, all the rights of the Constitution.
And this really gets into the persecution of Julian Assange, the lack of rights that he has. And Vidal, I know that you have worked in the embassy. You have seen him be subjected to very poor conditions, and that's putting it quite lightly. Would you like to weigh in with your thoughts? Here we are, several years later since the start of the extradition proceedings, but you have been involved with this case for quite some time. So why don't you just give us your thoughts?
Yes, sure. Apologize for joining a bit later than he was supposed to. Anyway, before I go to that, I just want to comment a few things on what was said here. It struck me that the judges didn't know much about these diplomatic assurances, because that's the very reason we are having this now.
Exactly.
That's why the courts reverted the original decision not to extradite him. The diplomatic assurances. They are called diplomatic because they come through the State Department, FCO, but they are signed by the prosecutor. Yeah, that's why they call diplomatic. It's the prosecutor issuing that. I was hoping for the lawyers to mention, when they talk about Vault 7, to mention the current situation of the Vault 7 whistleblower,
Okay.
Joshua
who
Shulkin.
is subjected to SAMS,
Yeah.
special administrative measures, and who is struggling there. Yeah, that was not mentioned. I was hoping to. The other thing that I hope it could be mentioned is that the CIA has practically admitted that he was spying on the embassy, and this comes as a result of the lawsuit taking place in the United States by these two journalists and two lawyers, all of that.
Yes.
The CIA is saying that this is somehow state secret. State secret. That's an admission that they were doing something that they don't want to disclose. Yeah, and I heard yesterday an interview by BBC4 to Stella. She did wonderfully, and she talked about Pompeo. I assume that was recorded interview because immediately after her, the journalist quoted Pompeo saying, "This is pure fiction. These journalists should be writing fiction or something." But there are some contradictions in there because in other occasions he has practically admitted,
Absolutely.
and something that I expect the lawyers could also bring into the court, is that this matches perfectly, and then we go to the embassy and the spying on UC Global, that we know, because it's the case in Spain against UC Global, we know by the testimony of the whistleblowers and by the documents that are being disclosed on the investigation, that they were plans to poison Julian Assange or to leave the doors open in order for him to be kidnapped. And we know that that was being done for the CIA, basically. And this is not a journalist writing a report with protected sources. These are documents that are being validated in court in Spain. So I think we will hear from the lawyers probably tomorrow, I hope.
Well, I gather it's the prosecution tomorrow.
Tomorrow is the prosecution?
Yes.
Oh, okay.
Craig, what are your thoughts on some of the comments that Fidel just raised here?
No, I think the case was made quite strongly that you are extraditing Julian to a country which planned to kidnap or even assassinate him, and which made active plans to kidnap or assassinate him, and therefore how can you be confident of how they will treat him in custody if they were planning to kill him? And I think that's an extremely important point. And the fact that it's not just dependent on the article in Yahoo News, but there is, first of all, we had protected witness 2 in the extradition hearings, actually giving direct evidence to this happening, and so much has come out in the court case in Spain. That this is not rumor or possibility, but this definitely happened. The CIA was planning to assassinate him. That's true. But I'd like to make another point. I was saying earlier that I thought the court appeared to give more serious consideration to the defence case than I'd ever seen a court give before in any of the Assange hearings. And I'd like to consider why that is. And this is where I think the fact that public opinion has turned round on the case, the fact that there's so much more support out there from Julian, the fact the campaigns have been so successful, the fact that almost all major media organisations have now started opposing his extradition, finally, a bit seriously. Even things like the fact we had 16 members of the European Parliament in court today, and we had members of national parliaments from all around the world. all of that campaigning is starting to pay off, I think. And we're now in a situation where once you have The Guardian and the New York Times and the Washington Post and other outlets all saying actively this should not be happening, judges can no longer be simply scornful or do not feel able simply to dismiss with no consideration the defence arguments. They feel under pressure to be at least seen to pay attention to the defence and listen to the defence. And I do think the different atmosphere in the court today wasn't in particular a reflection of the personality or character of the judges. It was to do with the way the whole atmosphere around this extradition has changed. There's now much more heavyweight opposition, if you like. And that comes down in large part to the success of the campaign and all the people who have campaigned and lobbied and worked so hard for many years. And I think that's very important. I think that shows that public opinion can be affected. And yes, I absolutely take Chris's point, he's absolutely right. We don't know how that will actually be affected by the eventual judgment when it comes. But the degree of respect shown to the defence case was due. I also agree with Joe. One thing that was very plain to me was the judges had read almost none of the background papers. They knew very little about the case. It was frequently obvious when the defence case were referring to things that had been said or done. They were always needing to be taken to the exact place. And it was fairly obvious they hadn't read it. You know, they were learning things they had not heard before, frequently, even though they were things which had been covered in the original extradition hearing. So my expectation after today is that these judges are going to go back and read through and read up and learn more. So I'm not expecting anything fast to happen after the American government replies tomorrow. I think we will then be in a position where the judges spend several months determining whether or not the hearing will go ahead. And that's several months in which we have more time to campaign to change public opinion further. Mm-hmm. But I do think what we saw today was evidence that campaigning and changing public opinion, changing media opinion, changing political opinion can actually affect the court. And I think that's very, very important.
Now, when you mentioned, Craig, the success of the campaigners, the advocates, the activists, I keep looking over here at Emmy because you have been a fierce advocate and defender of WikiLeaks, Julian Assange. As I mentioned at the introduction, you are also a member of the committee to defend Julian Assange. Can you speak about how you've seen over the past several years the support continue to grow and also expand and kind of cross beyond just, the different political parties or other activist groups?
Well, it's very interesting because from when I started to now, all those years that have gone past, each year that has gone past, Julian Assange's situation has deteriorated year by year by year. Yet public opinion has improved more on his side. Since his arrest particularly, we've seen a tsunami of change. Both at grassroots level, as well as political level, cultural level, internationally particularly. But I would like to make a distinction that this country, the UK, which has been the most ferocious polemist of WikiLeaks and Julian Assange, the establishment has resisted every opportunity to accept the points put forward in the defense of Julian Assange. An example this morning at Breakfast News, the BBC reported that Julian Assange was wanted by the US for leaking classified information. I followed it immediately with a complaint in the official procedure for BBC complaints. And this is something we've been trying to do for decades almost, trying to fight the narrative which is false. And the surprising thing is, even at this stage, on this day, where Julian Assange is facing probably his last effort to avoid extradition, the national broadcaster produces a false reporting. False reporting which undermines his defense as a journalist, as a publisher, presenting him as a leaker. So I'm, extremely satisfied by the campaigning, which has been remarkable, and great, recognition to his family, to Stella, and to everyone at every level that has been involved in raising the profile and having such fantastic results. But in this country, I find it, despite the popular opinion being on his side, very little opportunity politically to maneuver and influence the politics behind his extradition here, where the judges belonging to this country, this is the establishment they listen to, primarily. So there is this difficulty in this country in trying to influence the political environment.
You know, I was thinking, Nils Meltzer tells the story over and over again how he was fooled by all the stories that things like on what the BBC just reported, and then he looked into it and his mind was open. So maybe this little bit of ignorance that the judges displayed today, like on the informants issue, it was clear in September 2020 that the U.S. was going to push that informant story down everybody's throats. That was their main thing, at least that's what it seemed at the time. And then we started learning more and more. Mark Davis, the Australian journalist and lawyer, who said he was with them the whole weekend in the bunker at The Guardian, and he was the one who was redacting. The Guardian, everyone off playing golf. That's what he said, right? It was golf. And Julian did all-nighters. And then we learned about the fact that it was mentioned in court today, he didn't mention the newspaper, that one of the partners leaked the password to the unredacted files in their book, and that's how it got out there. And then others, Pirate Bay, Freitag, Krypton.org, all published the documents with the informant's names not redacted before WikiLeaks did. And that came up, and the selective prosecution was an issue brought up today. But I saw that the judges had no idea about this, because they believed this informant story, but what about the informants? It's like that's all they knew about the case at times. They kept bringing that up. And I think they were a little bit taken aback by that there's another side to this story. Let's hope that they, as Craig said, they go and start reading up on it.
Yes, Mark Summers could have made it a little clearer that it was the aberrant behaviour by one of the media partners that caused all
He
that.
kind of did, but
He kind of did, but he had
maybe there was a Guardian correspondent in the
Clearly
room. I don't
enough.
know. Was there?
Alan Rusbridger was in the room.
He was in the room.
Yeah.
Was he right?
Yeah, like that.
Well, it's the first. I've been to every single court hearing. It's the very first time,
Yeah.
and I'm glad that he did. He has a moral responsibility for where Julian is now, and it's never too late to make amends.
The judge referred to the joint statement that the newspapers did in 2010. Did you hear today? When she was referring to the judgment of the first judge, that she looked at it and she put in her documents the statement made jointly by these big newspapers condemning the
statement.
the release
Yes.
the release
Yeah,
of
that
the,
was an awful
of the
statement.
Cablegate. Yeah. So the
Yes, you knew
response from the lawyers immediately should be, well, that was 2010. We know a lot more about all this now. In the court, actually, this has been discussed, and the very papers that did the joint statement, all of them today oppose the extradition.
Exactly. Again, speaking to how the support has continued to grow and expand. Did you have a
No, I
point,
just wanted
Joe?
to, that you reminded me, I forgot about that. That really ticked me off because that was that statement that came out. They knew that they were responsible, the Guardian at least was, and they tried to blame it on Assange, on WikiLeaks, when they knew the truth and they put out that line statement, and it winds up being quoted today, years later, in the courtroom. So maybe they'll open their minds, hopefully, and get the real story about the informants, because
I thought he was weak on that.
who, Summers?
Yeah, I thought he was really weak because it wasn't. I thought he could have pushed back and made it clear that it wasn't WikiLeaks that was responsible for the leak of those names.
Yeah.
And in fact, his argument was there was no harm, and we have to balance out the public good with possible harm, and I thought that was probably the weakest.
Yeah.
His weakest moment. When you say, Craig.
Yeah, he did mention initially when it was first raised, he did say it wasn't WikiLeaks, it was the action of one of the newspapers involved, and he didn't specify the Guardian. It was almost as though he were protecting the Guardian at that stage. I found it strange. He didn't say outright, look, what happened is the Guardian, the deputy editor of the Guardian, and Luke Harding of MI6 published the password as a chapter heading in the book.
And Rusberg is in the room to confirm it.
And at the time, I was sitting there wondering why he hadn't.
Yeah.
I was thinking that there's obviously a reason, because Mark Summers obviously knows that, and there's a reason why he hasn't said it. Why hasn't he said it? And I kept wondering about it at various times during the day, and I never came up with a very good answer as to why he was trying
To be fair, he was brilliant in other parts.
Yeah,
Yeah.
it was great, but it was clear that the judges were clueless.
Yeah, that's true.
And that was let's call it a teaching moment. I mean, that was a moment when he could have laid out in detail, because they didn't have a clue.
No, they didn't.
And I don't think that he got through. I think that he was too opaque on a very important issue, because the judges didn't just raise it once. They raised that issue several times.
Couple of times.
Yeah, I wondered whether he had quite cottoned on to how little the judges knew, to the fact that the judges, that was one of the occasions when it just became very plain. The judges had not done their reading, they hadn't read the bundle, they had no idea what we were talking about most of the time.
But isn't that commonplace when it gets to a higher level? That
I'm not quite sure.
a complicated case like that?
I imagine it is, but is there a convention perhaps that lawyers are not allowed to point out that the judges don't know what they should know because they've read it? They haven't read the papers. If you see what I mean. Was he relying on the judges now going away and reading the papers? I'm not sure, but
Well, as an American watching all of this, it does have shades of Monty Python, with everybody with their wigs and your lord and my lady and the iron cage that looks like something out of Bleak House. I kept thinking of Bleak House actually. But in every courtroom I've been in, a good lawyer is overly obsequious and engages in nauseating flattery of the judge, no matter how clueless they are. So I think that there was one moment actually where I think it was Summers said something, and the judges reacted, and Summers was like, I don't know if you remember what it was, but he reacted like, you could see just this momentary, I can't believe you don't know what this is. I wish I could remember what that moment was. But it was clear that he was cognizant of the fact that they had not done their homework. They did not know the case.
yeah.
Well, right now, I do want to take a moment to welcome another guest who also happens to be the editor-in-chief of Truth Defense, which is the platform that we are streaming on, also a journalist, Mohamed Elmaazi. Glad you were able to make it here. I know you've been listening to the conversation for a little bit now. Is there anything in particular that you would like to touch on or expand upon?
Yeah, first of all, I wanted to say thank you to everyone who's able to make it, which is apparently everyone who was able to make it before me. Yeah, there was the point that I heard just a moment ago made about the arguments that Summers did and didn't present, or likewise with Fitzgerald. I think it is important to be fair to them and to note that A, they only have a day, B, the oral arguments are only certain arguments that they felt necessary to focus on and accentuate for the judges. There are obviously substantial written submissions as well, which went into certain subject matter that the oral arguments didn't. And it's important to remember that this is a permission hearing. So they're asking for permission to appeal. This isn't actually the appeal, even though they've been arguing some of the appeal grounds. And the focus, therefore, needs to be on grounds that they think will lead to them being granted an appeal rather than debating matters of fact which could lead to a back and a forth and a back and a forth, such as, for example, who released the full unredacted cables first, although Summers did note that it was Krypton that did it. So I think the reason why he was focusing in part on the proportionality test in relation to releasing information versus the public interest on the one hand versus the harm disclosures may have done on the other is because they're trying to convince the judges that there is a balancing test based on jurisprudence from the European Court of Human Rights that says you need to apply it in cases such as this, that Vanessa Breitzer did not apply, right? So since they're saying she didn't do this, it's therefore an arguable ground of appeal. This is a failure in law, and that's what they're trying to focus on. They're trying to have as many points of law where they can convince the judges it is at least arguable that Breitzer made a reversible error in law. And had she decided something differently, or had she applied the law correctly, then we could have ended up with a different result. So if they end up having more time with an actual appeal, then they can get into some of the other issues. But you have to be careful not to be drawn into sort of factual arguments with the judges that could end up eating up your time, where these are legal arguments they've got to be able to make. And I thought it was interesting to see which ones they chose to focus on and not focus on. Part of it will be based on what they think are most important arguments, and the other ones, perhaps the focus will also reflect the extent to which they think these arguments may be contentious, and therefore they need to verbalize them and give the judges the opportunity to question them on it, so that they don't just fail on the papers, basically. Because, like I said, most of the arguments are written down.
Excellent point. I see many of us here shaking our heads in agreement. Good point. I also do understand the other points raised here. I had the same feeling as well, that the judge seemed to be very fixated on this point about the redaction of the names. Anyone here want to follow up on these points?
I think another thing we haven't really emphasised is that the defence spent nearly half of their time on the no political extradition point. I mean, they absolutely hammered that point at great length, and I think I've always felt that that's unarguable. I've always found very strange the argument, which was accepted by the magistrate, that as the treaty is not incorporated in domestic law, then the terms of the treaty do not apply, even though it's a treaty under which you are extraditing. That seems to be quite remarkable. And and as Edward Fitzgerald put it, you can't at the same time apply the treaty for the extradition and refute the terms of the treaty. It almost seems like you don't have to say more than that. But in fact, the first 75 minutes of the defence case was spent hammering that out and giving further examples, because in many ways that seems to be the strongest and most basic point.
Well, I think also the fact that they did a very good job of defining espionage as a political act.
Yeah.
I thought that was very clever.
Yeah.
So okay, you want to extradite him for espionage. I thought he did. He had the legal background material to justify this statement that espionage is political in the eyes of the law.
Well, also starting with Chelsea Manning and saying, I was putting out the live tweets for Consortium News, and there must have been about 20 tweets in a row where I was quoting Mark Summers saying the Strasbourg court would say,
Yeah.
and how the Strasbourg court would defend Manning, would think that her leaking, because it was the offences of her employer, right? That's one of the cases where it is permitted, is protected. So they got from there by almost convincing the court that Manning should be protected, and then it was described as frivolous by Summers to pass on to prosecuting the publisher of this information.
Yeah, I thought that was really strong.
That was very powerful.
Yeah.
But the fact that they were mentioning Strasbourg, European Court, Strasbourg, I had a feeling that basically, not that they are giving up, we're going to go to the European Court anyway, but kind of saying it's going to go there and it's going to back here, correcting you, and you are going to be humiliated. So let's avoid that, because if you decide in this way, it won't pass the test on a proper court in Europe.
Yeah, get it right the first time rather than get
Yeah.
embarrassed by by
That
the
was the
European Court
feeling
of
I
Human
had
Rights.
That's a very interesting perspective as well. But you are correct, Craig, that especially at the beginning of the hearings, there was quite a bit of focus about the differences with the UK-US extradition treaty versus the UK Extradition Act of 2003. And it was also noted, and this is just some background information again to help the listeners understand some of the discussion here, it was stated several times in court and also addressed previously that under Article 4 of the US-UK Extradition Treaty, one cannot be extradited for political offenses. And obviously espionage is a political offense. As Chris was saying, it was very well outlined today. And it seems that it has been historically viewed in this way. You have the textbooks and the case precedent or case law to show for that as well. I think we are reaching potentially the end of this evening's discussion. So I just want to open it up. Any other points that you would like to address about this case, whether it has to do with what took place in the courtroom today, what is yet to come, or anything that has transpired over the past 4 years since these extradition hearings began. I believe the last time we were sitting here, some of you were returning guests. This was 4 years ago, almost to the day, 4 years ago. So this has been a lengthy process for Julian Assange. He has been in Belmarsh prison. That is the worst prison in the UK for nearly 5 years. So it's important to, of course, have these discussions which focus on the legal aspects of the case, the technical aspects, but to also remember this is a friend, a brother, a son, a father, a husband who is suffering tremendously. But I'll open it up. Anyone want to share their last thoughts?
Well, I would just say the pattern has been egregious violations of the most basic tenets of British jurisprudence, including eviscerating attorney-client privilege, charging somebody who wasn't in the U.S. and isn't a U.S. citizen with espionage.
Right.
I mean, the list is kind of endless, and I really think that's one of the reasons why they don't want it covered. I mean, at some level, they must be cognizant of the fact that they're just violating every legal norm to railroad Julian. So that has been the pattern from the inception. I don't expect that pattern to change. I think that I've seen, I would see others, Craig's followed it from the beginning, of course. That has just been consistent. And so, was it Craig who said, how could they possibly rule against him? And I think that if you were in a court of law or in a judicial system that wasn't a show trial but functioned, of course, that would be completely. But the pattern has been so incredibly egregious, and it doesn't matter what hearing or what court he's in. I think we should be cognizant of that as we, go into whenever this decision is given.
Absolutely.
And of course, we have to take into consideration that it's a man's life, because it has been said before that he may choose not to go to the US, ultimately taking the ultimate sacrifice. And is Britain and the society ready for the backlash of that?
Well, he told that to Niels Melzer, didn't he? Yeah, this is what he told
And
Niels.
so, exactly. And so Britain is playing with its reputation. No matter what the outcome, people in this country, including myself, will never stop pursuing the truth on this issue and the justice for him. Because the work of WikiLeaks is the reason why he is in there. The work of WikiLeaks has been an act of love, of self-sacrifice, the truest and most honourable motivation, informing the public for free. and treating people equally, because whoever goes onto WikiLeaks website is equal. It doesn't matter who you are, what you are, if you're rich or poor, or you're educated or uneducated, you're all equally treated. You can read information and learn and make informed decisions. There's nothing more honorable and nothing more expressive of the Western values of knowledge and enlightenment than what Julian has created. And to snuff out, after a long years of persecution, this honorable individual is a stain in British history which will never be expunged.
Very well said. Any other brief points?
Yeah, I think we have to remember this case is about political power. And it's about the ability of the state to hang on to power by keeping information from the public. And I think political power will dictate what happens next. My thinking is that it's very unlikely that the Biden people actually want Julian in the States before the election this year, because it's a complication in an election year, in a time when they've already lost the support of a lot of their left wing over Palestine and Gaza. And it's going to exacerbate that division. So I think these things will play out, and my expectation is nothing much will happen after tomorrow. That the thing will be kicked into the long grass, because in the meantime, of course, Julian is suffering. Julian is incarcerated. He's dying slowly in Belmarsh jail. They have him where they want him. So delay to them does them no harm. And my guess will be that after we hear the American evidence tomorrow, the judges will take several months to make up their mind.
Right, November 5th.
And then they will, well, they'll take several months to make up their mind, and then they'll probably allow an appeal on limited grounds. And that appeal on limited grounds will probably be November, December, January.
I would just say that having covered the CIA, that's a state within a state. They are untouchable. They have decided they want him. They don't really give a damn of the political consequences to Biden. So I don't think any U.S. administration, of course it was Trump the Trump administration that ordered the extradition. I think at this point the CIA's intent, and we have to remember that the CIA has transformed itself from an intelligence agency into a paramilitary force.
Yeah.
The CIA functions primarily now its own drone program, its own black ops program, its own death squads. And I have friends who served in Afghanistan, and these CIA teams would airdrop in the middle of the night into a village, and next morning the Rangers would go in and they'd blow them all. They're just out of control. So following the institution, I don't think any political figure in the United States is at this point capable of defying the CIA's demand that you bring Julian back here. And it is, as we saw in the court today, has nothing to do with the Iraq war logs. It is false. That's my read of it.
Excellent analysis. All right, well, that concludes this evening's Truth Defense live stream. I want to thank all of you for watching, and also our guests, Mohamed Elmaazi, Emmy Butlin, Chris Hedges, Cathy Vogan, Craig Murray, and Fidel Narvaez.
And Joe Lauria.
And Joe Lauria. Yes, Joe Lauria. All right, we will be back at it tomorrow, same time, Truth Defense live stream. It's a great pleasure to speak to you all, and thank you for watching. Take care and have a wonderful evening.
Thank you, Taylor.
Thank you.
Thank you.
Thank you.